This is The Situation Room, the home of hard-hitting political commentary and penetrating insights about the state of the nation. This is a talk radio experience like no other. The Situation Room, a place for hard truths, debates, and elevated conversations. The Situation Room, witty, political, engaging, deep, controversial. In the room, we have C.T. Muga, researcher, academic, seasoned political observer, a fountain of wisdom in these politically uncertain times. Ndu Oko, Nigerian by birth, Kenyan by choice, communications expert, Pan-Africanist, a truth seeker and believer in people power, and Eric Latin, agent provocateur, the man in the chair, seasoned journalist, news hound, a man who believes in punching up, not down. This is The Situation Room, the only way to start your day.
8 minutes after 8, how are you doing? Welcome to the third hour of Kenya's biggest conversation. This is The Situation Room. We are live on Spice FM, on KTN Home, on YouTube, on Facebook, on X, on TikTok, on Radio Garden, very many platforms. And we thank everybody who's joining us wherever you are joining us. We are Kenya's biggest conversation, just amplifying the voice of the people. Next, we want to have a conversation about the conflict of interest bill. It has been, going the rounds on all public platforms. Last week, we hosted Nairobi Senator Edwin Sifuna, who's among those who had voted yes to various amendments that were passed in the Senate to this bill. And we're talking about the EACC, the Ethics and Anti-Corruption Commission, and why the Ethics and Anti-Corruption Commission is uncomfortable and has expressed this displeasure with the amendments that came out of the Senate in particular. There are several other amendments that had come out of the National Assembly. So we have invited the EACC to come here so we can hear their side of the story. And we have with us David Kaboro. He is the Deputy Director at the Ethics and Anti-Corruption Commission in charge of ethics development and monitoring. David, good morning.
Good morning, Eric.
How are you doing?
I'm very fine, Eric.
Welcome to the hot seat of the Situation Room.
Thank you. Thank you for having me in this discussion.
How does it feel?
It is okay. It's a good opportunity for us to give our version of facts.
Very good.
And maybe help to shed the truth about this bill.
That's what we'd like. That's what we'd like. To welcome you to the conversation, CT will give you the proverb, but before he does, Ndu will tell you about your health insurance. You are thinking about health insurance for yourself, for your family. Maybe you have an elderly member of the family that you'd like to make sure that they have got proper health cover. Ndu, go.
Jubilee Health Insurance, it's the oldest insurer in the region, is it not? Yes, it is. So what it is that you'd be looking for, to be able to cover yourself and your family over, whether you're looking for something for the juniors, whether you're looking for something for somebody in the midlife, whether you're looking for something for folks who are in the elderly section of their lives, Jubilee saying, you know what, we can cover you. Your insurance that you need to go in and see the doctor, if you need for some kind of specialty care, if you need to travel and get travel insurance as well, Jubilee Insurance takes care of the length and breadth of all your medical needs into the millions, really. And there's a number you can call. Citi knows the number.
Of head Kwanzaa.
Jubilee,
Yeah.
0709 949 000.
There you go.
David, you see?
Yeah, I have got it.
The seniors cover works.
It definitely works.
Take care of everything.
Gives you peace of mind.
The number again, Citi?
Yeah.
0709 949 000.
Very good.
I got that also.
And if you'd like to visit them on their website, it's www.jubileeinsurance.com.
Thank you.
The proverbs this week are from another island in Africa.
Yes, an island nation, Cabo Verde, or otherwise Cape Verde, some people call it, Republic of Cabo Verde. When carrying an elephant's flesh on one's head, one should not look for crickets underground.
When carrying an elephant's flesh on one's head, one should not look for crickets underground. What's your interpretation of the proverb, David?
Well, that's a fantastic proverb. And I think it clicks in the mind automatically. I think it means when you have a heavier load, which is more important, you should not engage yourself or concern yourself with trivial issues. You need to just focus on what you are carrying because it might be more important. Thank you.
Very good.
Yeah, that's a good proverb.
Reminds us of PLO Lumumba at the Supreme Court, de minimis non curat lex.
Yes, true.
Yeah? Of the trivial, the principle that the law is not concerned with insignificant or minor matters.
It's true.
De minimis non curat in PLOs lex.
Wow.
All right, David,
Yeah.
you are in charge of ethics development and monitoring at the EACC. First of all, tell us what your job is, and then we'll come into this conflict of interest bill, because I'm sure it touches on ethics.
Thank you. Thank you, Eric. The Department of Ethics Development and Monitoring is one of the two departments that constitute the Directorate of Ethics and Leadership. The other department is Ethics Compliance. So as the words say, or as the names depict, when it comes to development and monitoring, we look at the various aspects that constitute ethics, and conflict of interest is one of them. So, these are areas that keep evolving. So we have to evolve with the times, and we have to make sure that they resonate with the needs of the country at any particular time. Then we also monitor how either the public entities or the public officers comply with those requirements. That is why it is simply referred to as ethics, development, and monitoring, because it involves development of those ethical issues and also monitoring how they are being complied with, mostly in the public sector, but also sometimes it extends to the private sector in particular instances.
One of the things that people have said, over many years, is that people who are in positions of authority, particularly in the public service, because of the knowledge that they have on what the government is planning to do, on what the government is doing on the budgets and all, have over time taken advantage of the knowledge that they have, the positions that they occupy, to eat where they work. Okay? And over time, they've called this ethical.
Yes.
Started with the Degwa Commission a long time ago that said, what's wrong? Mtu wa kule mahali anafanya kazi.
Yes.
Now then it has gotten to a point where people have raised the issue of, is there a conflict of interest when a public officer actually directly engages in profitable business from a private angle with the entity that he's working in? And I remember President Uhuru Kenyatta saying, you know what, we are going to bring in a conflict of interests sort of law.
Yes.
Now we have seen the conflict of interest bill 2023 in Parliament. Just give us the genesis of this bill. How did it end up in Parliament?
Yeah, thank you, Eric, for that. It's good that we give a historical perspective of how this debate has developed in this country. You have rightly mentioned about the Degwa Commission report. That was sometimes in 1971. The situation that was pertaining then was that public officers were really not engaging in any kind of business relationship with a government entity. That was maybe before independence and all the way up to the 1971. So when this commission was held and it gave recommendations in 1971, one of the recommendations was to allow public officers to engage in any business they may have in mind, subject to certain limitations and regulations. And that is how public officers started now engaging in various forms of doing business with government. And this is what now has led to the situation that we are in. And in a conference that was held sometimes in 2018, as you have rightly mentioned, the former president Uhuru Kenyatta, in that conference that was at Bomas of Kenya, the main observation that came out of that conference was that actually conflict of interest by public officers is what is driving mega corruption, or a lot of corruption in the country. In fact, the observations that were made was like almost 90% of the corruption and economic crime cases that we have are driven by a certain aspect of conflict by a public official, where a public official wants to take a private benefit or further a private interest in that consideration. And that is when now it was realized that the laws that we have are really not responding well when it comes to dealing with this aspect of conflict of interest by public officials. That is how that discussion metamorphosized into a call for action to look at the law, review this law, make it respond to that challenge, and The consideration then was to look at the various provisions that we have on conflict of interest, put them together, enhance them, review them, expand them, so that they are now able to deal with that challenge. And the then Attorney General constituted a task force that was now tasked to come up with this consolidation, including a study of other international best practice and incorporate all that into this law. And out of that task force, a bill was actually developed. It was looked into by various stakeholders. The task force itself was actually composed of participants from various entities that would call them key stakeholders in terms of driving the agenda on anti-corruption as well, but mostly on conflict of interest. So this bill was developed. It took quite a bit of time. Remember, there was the intervention of COVID at this point and various other interventions. And, the registration aspect also is a bit slow. So the final bill came out around 2020, 2021, and it was taken to the Office of the Attorney General for the final consideration. It is the Office of the Attorney General that now looks at bills that have been developed by other stakeholders. It kind of looks at it to make sure it is also in consonance and harmony with the various existing laws. And then it was taken to Cabinet in 2023. So Cabinet looked at this bill, they approved it, and of course with a few changes here and there, they were a bit minor. Then it was forwarded to the National Assembly for consideration. It stayed for some time in the National Assembly, a few months, I think from April of 2023 to around December.
It's not a few months, but okay, go on.
To us who are involved in the legislative process, when a bill takes 6-7 months in National Assembly, that to me is good.
Okay.
It can be termed as effective. So then it went to the Senate for concurrence, as do most other bills on corruption, because corruption is an issue that transcends both the national government and the county government. Now, at the Senate, it was again looked into. Remember, the National Assembly looked at the original bill that was drafted and accepted to by the Attorney General and the Cabinet. Yeah. The National Assembly had its input into that bill. When it was put before the committee of JIRAC, the Justice and Legal Affairs Committee, invited participants and the public, what we call public participation. It was very extensive. Many people looked at it. And by the time it was being taken to the Senate for concurrence, quite a number of things had changed. But it had still retained the character that would still say it can be looked into and maybe, looked positively. If it goes to the Senate and the Senate maybe it incurs here and there to improve it. So it went to the Senate, and at the Senate again, the Senate has looked at it, and I think that is, the rest is history. You know what happened. So now we have a bill that we call the Conflict of Interest Bill 2023, which has gone through that whole process. And as you have said, rightly so, we have expressed some reservations here and there. But I wouldn't say that they should be looked at as EACC objecting to this bill. It is making our input known as one of the key stakeholders, because fighting corruption, and especially when it comes to conflict of interest, it requires a multi-stakeholder approach. So the EACC is giving its version of input on this bill for consideration.
Okay, so why don't we jump into it then? What is the input that the EACC is giving that would cause a bit of contention then between the EACC and the Senate?
So, thank you, Madam Ndu. It is a bit difficult for me to pronounce that based on from where I come from, but I'll get used to it. But when you look at the bill, the resultant bill that has come out, we see a number of shortcomings and challenges that will pose a big challenge when we want to enforce this law. I don't know whether I can. Maybe I should start by looking at some of the flaws that we observe in this bill, but then later we can go into particular ingredients or various elements of this bill. Now, we want first of all to look at the enforcement structure of conflict of interest that has come out, which is now contained in this bill. Now, Section 5 of this bill, in the original bill, had indicated that enforcement of the bill. Okay, let me give you the history, first part of it. It had identified an enforcement structure that comprised, one, the EACC as the investigative body. Remember, the EACC has the constitutional mandate under Chapter 6 of the Constitution, because matters conflict of interest are actually in Article 75 of the Constitution. Article 75 is one of the chapters that is in the Constitution. But again, realizing that conflict of interest sometimes is more prevalent and it is more understood in the context of what a public entity does. So it had come up with the concept that we called reporting entities or reporting authorities. And reporting authorities constitute actually the plethora of the public entities out there.
Okay.
And their leadership. So the structure or the design of the original bill was that the EACC, despite being the main implementer or the main enforcer of this law, could designate various reporting entities and various reporting authorities for purposes of making it easy to enforce and ensure compliance with the requirements in the bill.
Okay. For example?
For example, it can say Chief Executive Officer, a CEO in a particular government entity, will be required to do ABCD in terms of making sure that the staff or the employees in that entity comply with particular requirements in this bill.
Okay.
For example, maintaining a register. I can use the very basic example, maintaining a register of conflict of interest. Then they would make periodical reports
To the EACC.
to the EACC.
Right.
Okay? And that is where the concept, a reporting entity, came. And you can see it being used consistently in the bill. Up above the EACC and the reporting entities and authorities, there is now the public officers themselves. They were also made part of the implementation structure, because various obligations, requirements under that bill were to be driven by the individual himself. Remember, conflict of interest is something that is more personal to an officer.
Yeah.
Even your own employer may not know some of these instances. So we have a compliance requirement that stems from the public officer himself, goes to the entity, and then the law enforcement bit, where, for example, a criminal element is ascertained or is suspected. So now, when this bill goes through these provisions, at the National Assembly level, that changed a bit. Now implementation was said it will be a dual aspect between the EACC and the reporting entities or the reporting authorities. What that means is that the reporting entities would also institute, for example, if something is suspected to be a conflict issue, they can undertake an investigation alongside an investigation by the commission.
Right.
And the National Assembly said, where a reporting authority or a reporting entity has commenced an investigation, then the commission cannot purport to undertake a parallel investigation on the same matter.
Okay. This is one of the things that was tweaked. That
Yes.
was not in the original draft. Is that what you're saying?
Yes, exactly. So this one came at the National Assembly level.
Okay.
So the import of that is saying,
Yes.
for example, if it's in a certain institution,
Yes,
the MD
yes,
of that public entity, let's just speak for purposes of just a conversation here.
exactly, yes,
The MD of the Kenya Ports Authority
yes,
is a reporting authority.
yes,
But in Parliament now we're saying that the MD,
yes,
if the office of the MD feels that there's an issue of conflict
exactly.
with an employee of the Kenya Ports Authority, the MD can institute an investigation to establish
Exactly.
the extent or whether there is a conflict that exists.
Exactly, that is the
And when
implication.
such an investigation is ongoing,
Yes.
EACC, please kaini kando,
Kaya kando.
tutawaambia, tutawaita tukimaliza.
Exactly.
Okay.
So that was the implication.
Okay.
Now let's go to the Senate. What happened at the Senate? Senate says now the commission should keep aside. Let us have the reporting entities being the main implementers, not the main, the only
The only implement.
implementers of this law.
Right.
So it means now the commission is kept aside. Now, first of all, in our view, this becomes unconstitutional because EACC has the statutory and constitutional mandate to deal with the abattoir's conflict of interest under Article 75 of the Constitution. So now we have a situation where now, using the case, the example that you have used, it is now the MD of Kenya Ports Authority to undertake that investigation as and when a case arises. And that is the situation.
What would be the problem with that?
Now, Madam Ndu, let's assume this is your company, or this is a public entity.
You're the MD.
You are the MD. You suspect Eric has a case of conflict of interest.
Okay.
Now, first of all, you are not an investigator.
No.
Your job is an MD. You deal with maritime issues, management of ships. Do you really have that capacity to undertake an investigation? Number two, maybe the aspect that Eric has committed to constitute conflict of interest is something you are also involved. Or it could be yourself. You're also benefiting from that. Okay? I don't know whether you can see a bit of a challenge.
I can see it very clearly. And I think this is now where the contention has come in, is it not?
Yes, exactly.
Shy of just saying it, that if somebody had their hands in the cookie jar, then why would you want to hire your own investigator to find out what you yourself are doing in the cookie jar?
Exactly.
No? Okay.
Exactly. Yeah. That is one of the concerns.
Okay.
Because when you look at this law, that is now the kind of interpretation that comes out.
Okay.
Yeah.
Let's move away from the entities, a government agency like the ports. Let's move to the county government. How would this law apply?
You see, in respect to a county government aspect, what the law had envisaged is that the commission, being the implementer of the law, could delegate. That's what I said in the beginning. It could delegate and designate somebody to be the reporting authority for a particular public entity.
And when you had this law, who did you envision? When you look at the number of people, I may use the word, I like the word you use, plethora of individuals whom we could choose from.
Yes.
What sort of office, what sort of individual did you see as being the sort of person who would be appropriate to be appointed to undertake such a task?
In fact, it was not even envisaged. It is already in the law, in the very draft bill. Maybe I can just highlight that section for you. In the very original bill, which I have with me
the
here.
The cabinet bill.
Yes, it's the one that was now taken to the National Assembly. And what was saying, a reporting authority in relation to a public officer means an office or body that is responsible for a public officer for purposes of this act, and includes an accounting officer, a person who exercises executive control over the resources of the entity, or any office or entity exercising a function delegated by the commission. So from that kind of definition, you can already start envisaging, with respect to accounting, definitely it would be, you can categorize maybe the county into two aspects. There will be the executive function and maybe the county, the assembly function. So at each of those two functions, we have somebody who is at the helm. So perhaps in what we had in mind is that we would now designate one of those persons to be the responsible person with respect to the county government. So we can have somebody reporting from the assembly side and from the executive function side. That kind of arrangement.
And this would be an individual whom the commission would designate, if I'm to understand.
Yes. Actually, the designation was supposed to be gazetted, so that this person, once he has been designated, he becomes the responsible officer for purposes of implementing, ensuring compliance with this law. And this person now has to make periodical reports to the commission.
And they have the full force of the law to require the public officers to disclose to them
exactly
any conflict and such.
Exactly.
Okay.
The
Let's
law
take a
had
break.
many provisions on the reporting aspect.
Let's take a break. We come back and continue this conversation shortly. 28 minutes to 9. We are talking about the conflict of interest bill, and our guest is David Kaboro. He is the Deputy Director for Ethics Development and Monitoring at the Ethics and Anti-Corruption Commission. So he's given us the genesis of this bill and up to the point where it got to Parliament. This journey began, like you said, in 2018. That conference, President Uhuru Kenyatta says, from what we are seeing, we need to have some legislation that actually deals better with conflict of interest. The Attorney General forms a task force. Task force goes and looks at laws, creates one bill, brings it back to the Attorney General. It goes to the Cabinet. It's approved by Cabinet. It goes to the National Assembly. And that's where now the journey started. The legislative journey proper. In the National Assembly, into the Senate, where we are at night now. This conversation continues shortly. Good morning.
This is the Situation Room, the only way to start your day.
From heart-pounding action to tear-jerking romance.
You will never lose me, Paul Atreides.
From mind-bending mysteries to side-splitting comedies.
Is that blood?
KTN Movie Experience, we have it all. Mystery, adrenaline, action.
9 seconds.
Now double that. Welcome home.
I make my Tuesday count by reading the Financial Standard. It helps me make much better and smarter financial decisions.
Setting the standard every day of the week. The Standard, Kenya's bold newspaper.
Jonathan Jackson is the founder and chairman of the Lordship Group.
HA Nairobi is a
Your skill set gives you an opportunity to survive in any country, wherever.
Why is it important to do many things, or maybe to get your hands in many different things?
You have to constantly evolve. That's constant. You're changing your source, you're giving them extra tokens every now and then. Keeps you fresh, keeps you relevant.
I agree. What do you think the meaning of life is?
Who you are able to impact in your journey.
There's something about Nigerians and just their dominance in the entertainment industry, which is one of the industries you're in. What's the secret behind that?
The secret is that the competition is high in Nigeria. If you don't keep evolving, Nigerians get carried away quickly. You might be the in thing today.
Oh yeah, but it keeps on changing.
It keeps on changing.
Yeah.
We don't wait for nobody.
Oh, that's why Burna Boy always keeps on releasing an album every year.
You have to release.
No one does it better for children than KTN Home.
We did it!
Red means stop, yellow means wait, and green means go.
Akili, akili.
I speak English.
Information, education, adventure, and excitement.
ABC 1, 2, 3, and do re mi. Come along and you will see. The more they travel, the more you know. Get ready, let's go.
KTN. Welcome home, kids.
Spice up yourself. Mornings done right. 94.4 Spice FM, Nairobi.
Our conversation continues. Conflict of interests by public officers in the positions of office or authority and dealing with public entities. for their own personal benefit. And there's a conflict of interest bill that has been in Parliament, is in the National Assembly, the Senate. It's gone back now to the National Assembly. Probably it will go into mediation. David Kaboro is the Deputy Director, Ethics, Development and Monitoring at the EACC. He's our guest. So, David, one of the conversations, we had a conversation last week with a senator, Edwin Sifuna, Senator for Nairobi. And he came with the bills. The bill that came from the National Assembly, the bill that left the Senate, and the bill that came into the National Assembly. And one of the things that he said was the EACC, in its objection, is saying that the Senate has deleted other laws and watered down the impact of enforcement of the ethics on conflict of interest by putting them here in this bill. And he took us through. So he said, for example, aspects of the conflict of interest bill that are in the conflict of interest bill that are also in the which one was it? A Public Officer Ethics Act.
Where? Public Officer Ethics Act.
And there's a section 42
of the ASECA,
of the Anti-Corruption and Economic Crimes Act that has been deleted. There's a section 46 of the Public Officer Ethics Act, I think, that was also deleted. So those kind of things. So basically, let's take with the section 42 of the Anti-Corruption and Economic Crimes Act.
Yes.
He said, what is provided for in the ASECA and what is provided for in the conflict of interest bill is the same. All we have done is now we have put it in clear language and put it into this bill. Now, EACC cannot say that they don't have a law that they can use to enforce matters of conflict of interest. And what those lawyers like Sifuna and others and their colleagues in the Senate were arguing is you do not want to go to court. And the judicial officer is having to rely on 4 different pieces of legislation that are talking about the same thing. And so instead of doing that, let's harmonize and put them into one. What's your response to that?
Thank you, Eric, for that. It's good to give us an opportunity to clarify that aspect, which is very critical. When we worked on this bill, one of the aspects that we looked into was consolidation of the various provisions that deal with the conflict of interest in the various other laws. It's important to have all these provisions on conflict existing in one legislation, which now provides a coherent way of dealing with conflict. Now, I just want to give one example because there are many in the bill, but let me just take one, which is very critical to this discussion. The aspect of public officers trading with government. We can now take an audit trail and see what was the effect and the implication in terms of the amendments that have been proposed.
Okay.
The first discussion was whether public officers should actually trade with government. Any government. At all.
Okay.
That is a discussion that I must admit it also divided the drafters of the bill. Because some were very sure that we should not allow any form of trading. Others were of the view that perhaps if we do that, we may legislate public officers into laziness or drive them out of their livelihoods. So the restriction that was agreed upon, and I think the National Assembly agreed with the drafters, is that what perhaps we should look at is restrict trading with your employer.
Okay.
With your employer. So
your direct employer.
Your direct employer.
If, for example, like City's example, if you work in Kiambu County,
yes, exactly.
Don't do business.
Don't
with
do
Kiambu
business
County.
with the Kiambu County.
Okay.
Okay. Now,
but you can do business with Mombasa.
You can do business with another county, but subject to some disclosure requirements.
Okay.
Okay.
Okay. But this, okay, go on.
Let me explain. Let me explain.
Yep.
Now, Section 42 of the Anti-Corruption and Economic Crimes Act was say it still says an agent of a private or public entity shall not have an indirect private interest in a decision that his priest is about to make.
And we were confused here. Agent, principal,
exactly.
entity.
Actually, I would have tried to to brief the senator, because I saw him struggling with that definition. But actually, that definition is provided in the Act itself.
Okay.
It is not in the definition parts of the Act, but it is at Section 38. And that definition already relates to that part. That is part 5
Read Section 38,
of the
please.
basis. So Section 38 says, in this part, agent means a person who, in any capacity, and whether in the public or private sector, is employed by or acts for or on behalf of another person. So it has two main components.
Okay.
An employee or somebody who is acting on behalf. It may not be an employee-employer relationship, but you are acting on behalf
So
of...
CT works for Kiambu County.
Yes.
Okay.
Yes.
Now, CT has an employee called Eric,
Yes.
who works in an entity where CT is a beneficial owner.
Yes.
That is agent.
Yes.
Eric now becomes agent.
Exactly.
Or CT is very closely related to Eric.
Yes.
In terms of Eric has married CT's daughter. Eric is agent.
Yes.
Okay, continue.
You see, I hope that that kind of definition becomes a bit clear, or it tries to shed light on this discussion.
It's clear, all right.
Yes. Now, something that Eric has touched about. Let's say you are in Kiambu, you are in Kiambu, but going to Mombasa. Okay. This bill had some provision. Remember, I said we isolated various aspects of how conflict manifests itself. One of the aspects which the bill provided for is something we call exchange programs. Okay. So an exchange program is something you can do in Kiambu County where you work. It will amount to conflict, direct conflict. So you decide to collude with Eric, who is in Mombasa. You exchange.
Nipatie hii job, nikupatie hii.
Unampatia kazi na yeye anakupatia.
But that is the reality of what happens in the county. Simple. It is the reality of how business is done in the county.
The bill now tries to control
it
that.
It has a provision on that, and various many other ways.
Does it still have that provision, or is it one of the things that was struck out?
No, that one is still there.
Okay.
It is still there. I think that was maintained.
Okay.
So, but I wanted to bring out what happened when it comes to doing business with government. So, Section 42 is where we have been charging many of those cases when it comes to conflict of interest. One of the aspects of benefiting from a contract or doing business with government, you are not the party itself trading.
No. Yeah.
But you are deriving a benefit out of that arrangement.
Yes.
Like a kickback.
A kickback,
Commission.
A commission.
A thank you.
Yeah. Is it clear?
A pathfinder.
So now, this bill in Section 19, I can read for you what it was providing for in Section 19. And it was saying, Section 19 of the bill, a public officer shall not be a party to or a beneficiary of, I want you to get those two elements, of a contract for the supply of goods, work, or services with his or her reporting entity. So as I said, Section 42 of ASECA, it had both elements, either being a party to or benefiting. That is the interest that is referred to in Section 45. The proposal that has come out in this bill is to retain, shall not be a party to, is retained, but what is removed or beneficiary of.
Oh.
This is a classic example where a word can have a radical effect on the consequence.
Like shall.
Repeat that again, please.
It says, a public officer shall not be a party to or beneficiary of a contract for the supply of goods, work, or services with his or her reporting entity.
This is what went from the cabinet to parliament. Right?
Yes, exactly.
Okay. What left the Senate?
What the Senate has proposed is to remove those words or beneficiary of.
So it just leaves you a party to.
A party to. Remember, let's say take an example of the governor. He will not award a company that reads Governor Kiambu versus the county of Kiambu. That is, he is a party to a contract, or even reads his wife.
Yeah.
He will give to a complete different entity but knows there is a relationship with that entity, and he'll get that benefit. And most of the cases you see in court today are actually based on that kind of arrangement. So a county will engage in a procurement, it will procure services, clean deal, work is done.
And then I'll buy a
Then
house.
now, 3 months down the line, you see this company that was paid now channeling money back. And it is very prevalent.
It just
not
buys
just
a,
in the county.
It buys a house.
Yes.
And then later that house, ends up being
Changes
transferred.
ownership. Exactly. Yeah.
It changes ownership
Exactly.
to a friend.
Some are even direct. They pay school fees for the
Children.
public official. Okay. They buy vehicles. These are matters in the public domain.
So, sorry, David, my question is this:
Yes.
that for me, as I look at it, I mean, I've not read the whole bill. I've read sections of it.
Yes.
But it seems as though it opens up gaping holes then for this kind of conversation now that is happening.
Yes.
Whereas many would ask, why don't we just close the whole thing and say that public officers should not do business
At all.
At all. Why are we doing this whole thing of maybe it shall, it shouldn't, it must, it
Beneficial
mustn't,
to
beneficial
agent
to
of.
party of?
Yeah.
That's where the confusion comes. Close the thing, say, you know what, you serve in public, you serve for the state, you're not doing business, end of story, kick caboodle out.
I'm actually very happy because now this is a national debate. It has come into the open. And these are some of the things that we need to grapple with and make a decision as a country. But again, there's something else I wanted to show you that has happened concerning the same aspect of trading with government. Because that was not the end of it. Look at the schedule of proposed amendments that have come out of the Senate. And one of the sections that has been proposed to be deleted, other than section 42 of the ASECA, is section 27 of the LEA, Leadership and Integrity Act. No, section 17 of the Leadership and Integrity Act. It is one of the sections that have been proposed to be deleted. And what does that section say? Section 17. It is titled Participation in Tenders. It says, a state officer or a public officer shall not participate in a tender for the supply of goods or services to a public entity in which he or she is serving or is otherwise similarly associated. But the holding of shares by a state officer or a public officer in a company shall not be construed as participating in the tender or public entity unless the state officer or public officer has a controlling shareholding interest. So this is a section that talks about participation in tenders by state and public officials. It has its safeguards. Okay. Now,
if I don't have a controlling interest, it's fine.
That may be what it was saying. Okay.
This is the Leadership and Integrity Act.
Yes.
At present.
As it exists.
As it exists. It was actually prohibiting.
Okay.
Now, this section has been put in one of the sections to be deleted. So the way it is, even it has a caveat. It has this caveat: shall not participate in a tender for the supply of goods or services. Okay. This aspect of saying having shares in a company, I can give an example. You don't have a controlling interest. So it can be argued, for example, Safaricom, you have shares. It cannot be said that if Safaricom tenders to supply internet to KTN, then, and I am an officer in Safari, I have shares in Safaricom, then I am the one. Shareholders are the owners.
Yes.
I think that was the gist of that arrangement.
Okay.
But now when we delete the entire thing, this caveat in the first part of this section disappears. If you compare that with what I was reading to you in section 19 of this bill, you can already start seeing the implication. And now what had the penal function in section 42 of ASECA has also been removed.
But I think this is, and I'm sorry, I think we can talk about the different removals or the inclusions, etc., etc. But we still continue to court corruption, and we still continue to say that then because we can change the law here or dibble-dabble here, that we're essentially allowing certain things to continue.
The spirit of this whole thing,
the whole thing for me
is to leave a window open.
For something to happen.
What
And
else?
we seem to be saying it's okay, and that I think also then there's a proverb City gave about, certain things being left open when the wind blows, because that's
One
exactly
day.
what happened.
Yeah.
That one day the wind will blow and it will be very clear, and it also leaves EACC wide open for target practice, because somebody can say, well, you guys all had this conversation about what should or should not be removed, so you allowed this thing to happen, making it all the more difficult when an issue of prosecution comes in. Then you don't really know how to deal with it, because you left the door open in the beginning.
And I think that is why, Madam Drew, that is why we are also making our concerns and voicing our concerns at this point, so that as this thing perhaps goes back to the National Assembly, some of these issues should be picked. And what we need to ask ourselves, what was the original intention of us having this law in the first place?
So tell
What
us-
was the concern that we
But
had?
tell us, what was the intention?
What's the spirit here?
Yeah.
What I would say is this. Conflict of interest had actually permeated all ways of life in the public sector. And we needed to have a way to deal with it wholesomely, in a way that will allow us to deal completely with conflict of interest. And that is why it was providing many, many avenues. For example, and I think we also need to clarify this. Conflict of interest should not be looked at as a crime per se or as an offense from the beginning, because situations of conflict exist with us. We are human beings. We have to be conflicted almost all the time. An example, you are a matatu driver. You are driving for passengers. In one of the stages you are picking passengers, you realize it is your son or your mother. Will you charge this person? Utalipisha, what will happen? Those are aspects that exist in our daily life. And the original intention of this bill was to provide avenues on how to manage. In fact, if you look at the words used in this bill, is to manage and regulate conflict of interest, as opposed to other words that are used in other laws, for example, combat.
Perhaps that's where we went wrong. Because when you manage, you're still accommodating.
You're accommodating.
Yes, and you are actually giving it a little window to flourish instead of extinguishing it completely.
I don't understand.
Let me give an example to put it in context. Assuming the president announces a cabinet today, okay? He names Eric the cabinet secretary for energy. Today, Eric is running 3 petrol stations.
Yes.
He has a company that imports fuel. Eric has an option of saying, first of all, disclosing at the point of appointment that, look, I do business in the energy sector. I have ABCD. And what I want to do about it, because I have been proposed for this position, is that if I am given this position, within 6 months, I am going to dispose all my interests in that sector. Okay? Or alternatively, you say, I would prefer to do business in this sector as opposed to take up a public appointment that will make me a regulator of this industry where I'm also a player. That was the kind of thinking that had gone into this bill. So it was providing many avenues on how you can deal or manage.
There was a supposition, and this is why I think I'm really confused.
Yes.
That there's a supposition that somebody who is involved in this kind of business is going to voluntarily give the information and say, actually, no, please, let me not take up this position or let me not do this business because I'm
conflicted.
I'm
conflicted.
But we know historically, that does not happen. It doesn't happen. So this is my question: why don't we plug the thing from the beginning? Why
then what happens, Ndu?
No,
so what happens if I get that appointment? No. Let's just let's get personal here because we're getting personal. Okay. So what happens if I get that appointment and I am actually a shareholder in a company that supplies fuel to government?
You resign. And you delinked.
Or you refuse the appointment.
Resign here. If you're a director, you resign. If you own shares, you offload them to your partners, meaning they cannot be any dotted line attaching you to that business that you did.
Either that or you remain in business, or and then you refuse the appointment.
City has nailed it on the head.
Yeah.
That was some of the procedures that were envisaged when we were coming up with this law. So it is now the duty on him or on you as the appointee to disclose at the very beginning. And one of the reasons why it is done in a public forum, because the public out there knows this information. So even if you hide some of those aspects, there are ways that they will still come out. And now, if you don't disclose some of those things, those are the elements that we have now criminalized. That if you knew and you did not disclose, yet you took up that appointment, we don't even have to wait for you to favor that company.
That's it. You're done.
The fact that you did not give the information,
criminal
it is
offense.
already an offense. And we go to the law enforcement.
Ndo is asking, why leave that whole window there?
Exactly. Because it's like, we're saying, we're sitting around the table and we already know that you're in this direction. We know where you are, but we're still saying, okay, let's just accommodate it and
let's allow him
to do until this point.
Actually, the thing that the county governments and the system has enabled us to do is to have a front row seat to understand how conflict of interest actually works.
Proper
Because
in
all
the
cases
practice.
that we hear being brought up by the Auditor General, so and so, this relative, this cousin, wife's relative, daughter. So it's not complicated. And when you go deeper, you will find the very thing you said. Yes, I am governor of Kiambu, but Eric is governor of Kajiado. I am going to make sure that we do business. So it is never me.
It's not in Kiambu.
So there's no conflict. Now, Ndu's point is valid insofar as we're saying, look, we actually know how these things are done. And here we are laymen. We are not even investigative officers like yourself. So this law, in many ways, even fell short of what would actually work to extinguish this problem.
In conclusion, Brother David, because we are coming to the end of what next for this bill? Sifuna says, please come to the Senate. Let's hear you out. What next for this bill?
I would say categorically that we are very open to having a national dialogue, a national conversation on this aspect, because conflict of interest is here with us. It is not going away anytime soon. And as I said earlier, let us ask ourselves, what is this challenge that we wanted to deal with? Is it still with us now? What is this medicine that we have proposed?
Spice up your life.
But still we have faith in our parliamentary system, and we hope
You have faith.
David Kaboro is the Deputy Director for Ethics, Development and Monitoring at the EACC. 9 a.m.
This is the news wire. Detectives are interrogating a suspect